The modern view, which you'll see more often now, simplifies this significantly. Instead of having separate crimes for most accessories, being an accomplice or accessory is generally not a distinct crime in itself. Instead, it's viewed as a theory of liability.
A theory of liability, what does that mean?
It means it's a way to link a person to the crime committed by the principal, holding them responsible for the principal's crime. So, under this modern view, the principal is the main actor, responsible for the target crime and any foreseeable crimes that arise from it. And an accomplice is basically anyone else who intentionally aids or abets that principal.
So it merges principals in the second degree and accessories before the fact into just accomplice.
Largely, yes. An accomplice is a person who, with the requisite mens rea, meaning they specifically intend for the crime to be committed, aids, encourages, or abets a principal in the commission of that crime.
And what are they liable for? Just the main crime?
Here's where it gets broader. The scope of accomplice liability extends not only to the specific crime they intended to aid, but also to all other crimes committed by the principal that were natural and probable or reasonably foreseeable consequences of the accomplice's conduct in aiding the initial crime.
Wow. So if you help someone commit a robbery by providing the gun,
And during that robbery, the principal foreseeably uses the gun to shoot and kill someone.
you, the accomplice who just provided the gun, could be liable for the murder too.
Potentially, yes. Even if you didn't pull the trigger or even intend for anyone to get killed, if the killing was a natural and probable consequence of the armed robbery you aided, you could be on the hook for felony murder as an accomplice. It shows how serious the law takes aiding criminal enterprises.
That's a crucial concept. It's not just a minor role. You can be liable for major unforeseen consequences.
Absolutely.
But what if an accomplice has a change of heart? Can they withdraw from the plan and avoid liability? It sounds like it wouldn't be easy once things are in motion.
You're right, withdrawal is possible, but it's a very high bar legally. To effectively withdraw and potentially avoid liability for future crimes committed by the principal, an accomplice generally must. First, repudiate any prior aid they provided. Basically, take back whatever help they offered.
Can't just say, I'm out.
No. Second, they must do all that is possible to countermand that prior assistance. This might mean actively trying to stop the crime, warning the victim, or notifying the police. You can't just walk away. You have to actively try to undo your prior help.
Okay, repudiate and counteract.
And third, this must usually be done before the chain of events is in motion and unstoppable. If the crime is already happening or is inevitable, or if their attempt to withdraw won't actually prevent it, the withdrawal might not be legally effective.
So you have to act decisively and early.
Yes. It shows the law's strong stance on group culpability once a plan is put into motion. Withdrawal is designed to be difficult to encourage people not to participate in the first place.
Makes sense. Okay, sometimes the question isn't whether an act was committed or even intended, but whether the person had the capacity to be legally responsible for it. This brings us to responsibility defenses, which directly challenge the defendant's mental state or maturity at the time of the alleged crime.
Exactly. These defenses argue that the defendant, for some reason, lacked the necessary capacity to form the required mental state or to understand the wrongfulness of their actions.
Yeah.
One of the most complex and, frankly, controversial responsibility defenses is insanity.
The insanity defense. We hear about it a lot, but it seems really hard to prove.
It is very difficult and legally complex. For insanity to be a defense, its elements must have been present at the time the crime was committed, not just at the time of trial. And crucially, there isn't just one test for insanity. Jurisdictions adopt different legal tests, and the choice of tests can lead to dramatically different outcomes.
Different tests. What are they?
There are 4 primary legal tests you need to know. First, the Imnaten rule. This is often called the right from wrong test.
Okay.
It asks whether the defendant, at the time of the act, due to a defective reason from a disease of the mind, did not know the nature and quality of the act they were doing, or, if they did know it, they did not know that what they were doing was wrong. It's a purely cognitive test focused on understanding.
Did they know what they were doing, and did they know it was wrong?
That's the essence of a Knighton. Second is the irresistible impulse test. This test focuses less on knowledge and more on self-control.
Control.
Yes, it asks whether the defendant, due to a mental disease or defect, lacked the capacity for self-control and free choice, meaning they were unable to conform their conduct to the requirements of the law. They might have known it was wrong, but they couldn't stop themselves.
So Knighton is about knowing. Irresistible impulse is about control.
Correct. Third is the Durham rule, sometimes called the product test. This is a much broader and now largely abandoned test. It simply asks if the unlawful act was a product of the defendant's mental disease or defect.
Just product of. That sounds vague.
It is, which is why most jurisdictions moved away from it. It was seen as giving too much power to psychiatric testimony without a clear legal standard.
Okay. And the fourth test?
The fourth, and quite influential, is the Model Penal Code, MPC test. This is essentially a composite test combining elements of Imnaten and the irresistible impulse test.
Best of both worlds.
Kind of. It asks whether, at the time of the conduct, the defendant lacked substantial capacity, either to appreciate the wrongfulness, criminality of the act, or to conform his conduct to the requirements of the law, all due to a mental disease or defect.
Substantial capacity. Appreciate wrongfulness or conform conduct. So it covers both knowledge and control, but uses substantial capacity.
Exactly. It's seen as a more modern and nuanced approach than the strict Imnaten or irresistible impulse tests alone. The key takeaway is that these tests are distinct, and the specific test used in a jurisdiction can dramatically impact whether an insanity defense succeeds.
Definitely something to check for in a specific jurisdiction. Okay, besides insanity, what other responsibility defenses are there?
Another very common one, especially on exams, is intoxication. But you have to be very careful here to distinguish between voluntary and involuntary intoxication.
Okay, voluntary intoxication first. That's just choosing to drink or use drugs, right?
Essentially, yes. Voluntary intoxication occurs when a defendant intentionally takes a substance known to be intoxicating. It's important to note the defendant doesn't need to intend to become intoxicated, just to intentionally take the substance.
And is that a defense? People always say being drunk is no excuse.
That's largely true, but with a crucial exception. Voluntary intoxication serves as a defense only to specific intent crimes, remember FIOT, and under the MPC, to crimes requiring a purposely or knowingly mental state.
Only for specific intent. Why?
Because the defense works if the intoxication prevents the formation of that requisite specific mental state. If someone is so intoxicated they literally cannot form the specific intent to, say, permanently deprive someone of their property for larceny, or to commit a felony inside a dwelling for burglary, then the intoxication might negate that element.
But it wouldn't work for general intent crimes?
Generally not. It's typically not a defense to general intent, malice, or strict liability crimes. The reasoning is that you can still form the general intent to do the act, like punching someone for battery, even if you're very intoxicated. You chose to get intoxicated, so you're generally held responsible for general intent actions taken while in that state.
Okay, so voluntary intoxication only helps for specific intent crimes if it negates that intent. What about involuntary intoxication?
Involuntary intoxication is different. This occurs when an intoxicating substance is taken without the defendant's knowledge of its intoxicating nature, like being given a spiked drink, or when it's taken under duress, forced consumption.
Someone else caused you to be intoxicated.
Exactly. And because the intoxication wasn't the defendant's fault, the law treats it much more broadly as a defense. Involuntary intoxication can serve as a defense when the intoxication negates any element of the crime.
Any element. So it could work for general intent, too.
Yes. It can potentially apply to specific intent, general intent, or even strict liability crimes if the level of involuntary intoxication truly prevents the defendant from fulfilling any required element, whether it's the actus reus or the mens rea. It functions much more like an insanity defense in that regard. Did the involuntary state prevent criminal liability from attaching?
That's a critical distinction. Voluntary, only specific intent. Involuntary, essentially any crime.
Absolutely critical to get right.
Okay. Any other major responsibility defenses?
The last one is immaturity or infancy. This deals with the age at which a person can be held criminally responsible.
Kids committing crimes.
Right. At common law, there were very clear age-based rules. A child under 7 years old conclusively could not be convicted of a crime. Too young to form intent.
Okay, under 7, no criminal liability.
For children aged 7 to under 14 years old, there was a rebuttable presumption that they were incapable of committing a crime.
Rebuttable, meaning the prosecution could try to prove otherwise.
Exactly. The prosecution could present evidence to show that this specific child, despite being under 14, understood the wrongfulness of their actions and could form criminal intent.
And over 14.
Children 14 years or older could be charged and treated as adults under common law.
How does it work now? We have juvenile courts.
Yes. Modern statutes typically replace these rigid common law rules. They usually set a specific minimum age for criminal conviction, often somewhere between 11 and 14 years old, depending on the state. Below that age, children are generally handled exclusively by the juvenile justice system, which focuses more on rehabilitation than punishment. Even above that age, many young offenders start in the juvenile system.
Okay, so age matters, and the specific rules depend on the jurisdiction's statutes. Wow, that covers the general principles and responsibility defenses. Now we move into specific categories of crimes, starting with the most serious, homicide.
Yes, Chapter 2, Homicide. When a death occurs, the legal questions become incredibly complex, and the level of culpability varies wildly. Homicide covers a vast spectrum, as you said, from the most malicious, premeditated intent down to utterly unintentional acts that still result in death.
How do we start breaking down this huge category?
For analytical purposes, especially for your bar exam preparation, we generally divide unlawful homicides into three main categories. First, murder, which involves a concept called malice aforethought.
Okay, murder.
Second, voluntary manslaughter, which is an intentional killing, but one that is mitigated by certain specific circumstances, reducing its severity.
Intentional but mitigated.
And third, involuntary manslaughter, which is an unintentional killing, typically resulting from criminal negligence or occurring during the commission of some other unlawful act.
Unintentional killing. Okay, murder, voluntary manslaughter, involuntary manslaughter. Let's start with murder. You mentioned malice aforethought. That term sounds old-fashioned, but seems key.
It is absolutely key for common law murder. Common law murder is defined as the unlawful killing of another human being committed with malice aforethought. And, critically, like all result crimes, there must be a causal relationship between the defendant's actions and the victim's death.
So what exactly is malice aforethought? Because you said earlier with malice crimes, it's not always about pure evil intent.
You've hit on a critical point again. Malice aforethought, despite the name, doesn't always require premeditation or ill will in the everyday sense. It's a legal term of art, and it can be established in one of four ways at common law.
4 ways to show malice. Okay, what's the first?
The first and most obvious is intent to kill. If the defendant directly intended to cause the death of the victim, and their actions legally caused that death, that's malice aforethought.
Straightforward enough. Kill someone on purpose.
Second, intent to inflict serious bodily injury. Even if the defendant didn't specifically intend to kill, if they intended to cause severe physical harm and the victim dies as a result of those injuries.
That still counts as murder.
Yes, that intent to inflict serious bodily harm is sufficient to establish malice aforethought for common law murder. The law essentially says if you intended to hurt them that badly and they died, you're responsible for murder.
Okay, intent to kill or intent to cause serious bodily harm. What's third?
Third is often called depraved heart murder. This involves a reckless disregard for human life. It's an unintentional killing that results from the defendant's reckless indifference to an unjustifiably high risk to human life.
So not intending to kill, but acting so recklessly you obviously could.
Exactly. Think of someone firing a gun randomly into a crowded room, or playing Russian roulette, or driving drunk at extremely high speeds through a residential area. They might not want anyone to die, but their conduct shows such an extreme indifference to the value of human life that the law equates it to malice. It's that I don't care if someone dies mentality.
Depraved heart. Okay. And the fourth way to show malice.
The fourth way, and this is a very, very frequently tested area on the bar exam, is the felony murder rule.
Ah, felony murder. I've heard of that. Killing someone during another crime?
Precisely. Felony murder is an unintended but foreseeable killing that occurs proximately caused by and during the commission or attempted commission of an inherently dangerous felony.
Inherently dangerous felony? Like what?
The common law and many statutes identify certain felonies as inherently dangerous to human life. The most commonly tested ones are summarized by the mnemonic BARK.
B-A-R-R-K. Okay, another mnemonic. What's this one?
Burglary, arson, rape, robbery, and kidnapping.
B-A-R-K felonies. Got it.
If a death occurs during the commission or attempted commission of one of these BR felonies, the intent to commit the underlying felony is sufficient to establish the malice aforethought needed for a murder conviction, even if the killing was accidental or unintentional.
So you don't need a separate intent to kill during the robbery, for example, just the intent to rob.
Correct. The intent to commit the inherently dangerous felony substitutes for the malice required for murder. It's a strict rule designed to deter dangerous felonies.
Wow. That's broad liability. What if, say, during the robbery, the victim pulls a gun and shoots one of the robbers? Is the other robber guilty of felony murder for their co-felon's death?
That brings up some complex limitations on felony murder. When someone other than a co-felon is killed, say, a bystander or police officer, or when the death results from resistance by the victim or police, the defendant's liability often depends on which specific legal theory the jurisdiction follows.
Different theories.
Yes, the agency theory, which is the majority position in the U.S., states that the defendant felons are not liable for such a death if the person who actually caused the death, like the victim resisting or the police, was not one of the felons or their agent. Their actions are seen as independent.
So under agency theory, if the victim shoots a bystander while resisting the robbery, the robbers aren't liable for that death.
Generally, no. But under the proximate cause theory, which is a minority position, the defendants are liable because the death is seen as a direct and foreseeable consequence of them committing the felony, regardless of who actually pulled the trigger.
So under proximate cause theory, they would be liable in that scenario.
Correct. It's a broader scope of liability.
Mm-hmm.
And finally, regarding your question about a co-felon being killed, under the red line doctrine, which is followed by most jurisdictions, a defendant is generally not guilty of felony murder when a victim or a police officer kills one of the defendant's co-felons.
Why not?
The reasoning is often that the killing of a co-felon by a resisting victim or police is considered justifiable homicide, and it's not seen as being done in furtherance of the underlying felony by the defendant's hand or agency. So the red line doctrine usually shields surviving felons from murder liability when their partner in crime is killed by a non-felon during the crime.
Agency theory, approximate cause theory, red line doctrine. Lots of nuances in felony murder.
Absolutely.
Yep.
Pay close attention to the facts and which theory might apply if it's mentioned.
Okay, so common law gives us malice aforethought and the felony murder rule. But modern statutes often refine this into different degrees of murder, which is how we usually hear it discussed.
Exactly. Modern statutes, which you absolutely need to be aware of for the bar if a statute is provided in the question, typically divide murder into first-degree murder and second-degree murder.
What's the difference?
First-degree murder is typically reserved for the most culpable killings. This usually includes killings that are deliberate and premeditated.
Deliberate and premeditated. What does that mean exactly? Like long-term planning?
Not necessarily long-term. Premeditation means that the defendant planned the killing or reflected on the idea of killing, even if only for a very brief time. The key is that it's not an impulsive, spur-of-the-moment act. There was some opportunity for thought, some reflection, however brief.
So even a few seconds of thought could be enough?
In some jurisdictions, yes. Deliberate means acting with a cool mind, capable of reflection. First-degree murder based on premeditation and deliberation is considered a specific intent crime.
Okay. Any other ways to get to first-degree murder?
Yes. Many statutes also automatically elevate certain types of killings to first-degree murder, regardless of specific premeditation. This often includes certain enumerated felony murders, sometimes beyond the BR felonies, depending on the statute, or killings committed through particularly heinous means, like bombing, poisoning, or torture.
So premeditated killings, or certain statutorily defined killings, that's first-degree. What's second-degree murder then?
Second-degree murder is essentially a catch-all category for other murders committed with the necessary malicious intent, that is, intent to kill, intent to do great bodily harm, or a depraved heart that do not meet the requirements for first-degree murder, like lacking premeditation or not being one of the enumerated types.
So it's still murder with malice, just not the worst kind under the statute.
Exactly. Like common law murder, second-degree murder is generally considered a malice crime. And remember, this is crucial. These degrees of murder didn't exist at common law. Therefore, when you're facing a problem on the bar exam, the fact pattern must supply a statute defining degrees of murder for you to analyze first and second degree. If no statute is provided, you analyze it under the common law murder framework, just murder with malice aforethought.
Got it. Statute needed for degrees. Okay, now what happens when an intentional killing has mitigating circumstances? It's still a death caused by intent, but the law acknowledges that certain situations, often highly emotional ones, can reduce the culpability. This is where voluntary manslaughter comes in, right?
That's exactly right. Voluntary manslaughter is defined as a homicide that would otherwise be murder, because it was committed with malice aforethought, typically intent to kill or cause serious bodily harm. But where that malice is mitigated down to manslaughter due to certain recognized circumstances.
Mitigating the malice, what kind of circumstance?
These mitigating factors generally fall into two main categories: killing in the heat of passion, resulting from adequate provocation, or killing under an imperfect defense.
Okay, let's take heat of passion first. What does that involve?
Heat of passion refers to a killing committed while the defendant is in a state of intense emotional disturbance caused by adequate provocation. For this defense to apply and reduce murder to voluntary manslaughter, two tests must generally be met.
Two tests. Okay.
First, a subjective test. The defendant must have actually been provoked and acted in the heat of passion. They were genuinely enraged or disturbed. Second, an objective test. The provocation must have been severe enough that it could inflame a reasonable person to act out of passion rather than reason.
So the defendant was actually mad, and a reasonable person would have been mad too.
Essentially, yes.
Yeah.
And the defendant must not have had time to cool off between the provocation and the killing.
What counts as adequate provocation?
Classic examples include things like being subjected to a serious battery, facing a credible threat of deadly force, or discovering one's spouse in the act of adultery. Mere words are usually not enough, no matter how insulting.
So finding your spouse with someone else could be adequate provocation.
Traditionally, yes, that's a common example. But the critical limitation is the cooling off period. If there was sufficient time between the provocation, like discovering the adultery, and the killing for a reasonable person to regain their self-control, then the killing remains murder, not manslaughter. The heat of passion must be immediate and directly linked to the provocation.
The anger has to be fresh, basically.
That's a good way to put it.
Yeah.
An interesting nuance here is transferred provocation, sometimes called transferred heat of passion. This can apply if the defendant, due to a reasonable mistake of fact, kills the wrong person, thinking they were the provoker, or misidentifies the provoker, but they would have been guilty of voluntary manslaughter had they killed the actual provoker. The provocation can effectively transfer to the unintended victim in that limited scenario.
Okay. Heat of passion mitigates murder if provocation is adequate, defendant is actually provoked, and there's no cooling off time. What was the other way to get voluntary manslaughter?
The second mitigating circumstance is often called imperfect defense. Many states will reduce a murder charge to voluntary manslaughter when the defendant claims they used deadly force necessary for self-defense or the defense of others, bet either. 1. The defendant was the initial aggressor in the situation, or R. The defendant's belief in the necessity of using deadly force was unreasonable.
So they thought they needed to use deadly force, but they were wrong, or they started it.
Exactly. It's an intentional killing, but the defendant's genuine, though flawed or unreasonable, belief in the need for self-defense mitigates the malice from murder down to voluntary manslaughter. They weren't acting with pure malice, but with a mistaken or imperfect claim of justification.
Got it. Voluntary manslaughter, intentional killing minus malice due to heat of passion or imperfect defense. Now, what about killings that were never intended at all? This brings us to involuntary manslaughter.
Right. Involuntary manslaughter covers unintentional homicides. It's typically defined as an unintentional killing committed with criminal negligence, which under the MPC usually equates to recklessness, or a killing that occurs during the commission of an unlawful act that doesn't qualify for felony murder.
Criminal negligence or during another unlawful act. Let's break that down. What counts as criminal negligence here?
Criminal negligence is generally a higher degree of carelessness than ordinary tort negligence. It often requires a gross deviation from the standard of care, where the defendant should have been aware of a substantial and unjustifiable risk of death or serious injury. Under the MPC, this often aligns with the mental state of recklessness, consciously disregarding that substantial risk.
So extreme carelessness leading to death.
Yes. And the other way to get to involuntary manslaughter is through that unlawful act prong. This typically arises in two situations. First, under the misdemeanor manslaughter rule. This is similar to felony murder, but for lesser crimes. It applies when a killing occurs during the commission of a malum, in se as misdemeanor, meaning a misdemeanor that is inherently wrong, like assault or battery. The commission of the wrongful misdemeanor is seen as applying the culpability for the resulting death.
So if you commit a simple battery and the person unexpectedly dies, it could be misdemeanor manslaughter.
Potentially, yes, if the misdemeanor was malum in se and the death was a foreseeable result. Second, involuntary manslaughter can apply to a killing committed during the commission of a felony that is not one of the inherently dangerous felonies triggering first or second-degree felony murder under the relevant statutes.
So felonies that aren't BRR or otherwise listed for felony murder.
Exactly. If a death results from a less dangerous felony, it might fall under involuntary manslaughter instead of murder. It's the unlawful act combined with the unintended death that forms the basis for liability.
Okay, that clarifies the homicide categories. Murder, malice, voluntary manslaughter, mitigated malice, And involuntary manslaughter, unintentional negligent. That's a huge area covered.
It is. Homicide analysis is central to criminal law.
Now let's shift gears slightly in Chapter 3 to other crimes, focusing first on crimes against property. Beyond taking a life, many crimes revolve around taking or damaging property. These seem like they'd have very specific elements, too.
They absolutely do. And distinguishing between them is critical, as the elements often overlap slightly, making them prime candidates for confusion on exams. Let's define the main ones, highlighting their key distinguishing features.
Perfect. Let's start with the most basic, stealing, larceny.
Right. Larceny, at common law, is the trespassory taking, meaning taking it without the owner's consent and carrying away, even a slight movement counts, of the tangible personal property of another, with the specific intent to permanently deprive the owner of that property.
Trespassory taking, carrying away, personal property, intent to permanently deprive, lots of elements. What if you just intend to borrow it?
If you genuinely only intend to borrow it and then return it, that generally negates the intent to permanently deprive, so it wouldn't be common law larceny. The intent at the time of taking is crucial.
Okay. What's larceny by trick, then?
Larceny by trick is essentially larceny accomplished through fraud or deceit. The defendant tricks the victim into voluntarily handing over possession of the property, but the victim does not intend to pass title, ownership. The defendant, meanwhile,